Welcome back, everybody, to land law. We are going to be moving on in this lesson to the first of our major topics related to land law. So we've sort of parked the introductory and theoretical approaches behind, and now we're going to start to talk about the registered title system, or sorry, the unregistered title system, specifically unregistered land. We'll take an introduction to the concept of unregistered land in this lesson, and then we will start to look at various other subsidiary issues pertaining to unregistered land over the next few lessons. So things like, for example, the doctrine of notice, as well as land charges and the way in which land charges operates. So ultimately, we're going to talk about the process of conveyancing in unregistered title, as well as the methods of protecting legal and equitable interest over unregistered land. And ultimately, this is the thing that is going to be most important for what we are going to be examining. Because at the end of the day, when we think about the purchase of land, whether it be registered or unregistered, we'll talk about the delineation in future lessons, but when we think about the purchase of land, there are a number of major concerns that we have to identify. And it is these main concerns that the law exists to essentially alleviate and to essentially operationalize. So when we talk about both the unregistered and the registered title system, we're going to talk about the fact that there are two major issues that we have to identify in terms of purchasing registered title. Now, the main difference between the two, the main difference between unregistered title and registered title, is that essentially land is continually and increasingly being entered into the land registry and becoming registered title. So this is something that was established many years ago with the Land Registration Act and all these kinds of things. But ultimately, the land register is now the way in which you identify a number of the major concerns when it comes to the purchase of title. So, for example, working out who actually is the sole legal owner of the title. That is something that is done through the land register when we talk about registered title. And then when unregistered land is conveyanced in a particular way, it becomes registered in the future because it becomes entered into the land register. So unregistered title is an increasingly rare occurrence in modern land law, but it still does exist. There is a certain percentage of land in the UK that is unregistered still, but for the most part, we're talking about registered title. And as a solicitor, if you operated as a sort of property solicitor or a real estate lawyer or something like that, you will be most of the time focusing on the concept of registered title. When it comes to the transfer of title, whether it be registered or unregistered, whether it be through either of these systems, there are two major questions that a purchaser will be concerned in. Okay, the first is, how do I know who owns the title in question? How can I prove that the person who I'm going to give a lot of money to and who I'm going to essentially put my trust in the purchase of this land, how do I know that person actually owns that title and has good standing in terms of ownership of that title? That's question one. Question two is, how do I know what legal or equitable interests exists over the title? Because there are some legal interests and equitable interests that will bind me as a purchaser. So if I'm purchasing this title, I want to know what other third-party interest exists over this title, because it might bind me. I might have to adhere to the rights of those interests. And so as a result of which, I need to ask that question as well. And then these are the two main concerns that we're going to explore in this future, these sets of lessons. This lesson specifically, we're going to talk about the first question, specifically with reference to unregistered land. So we'll talk about how I know who owns the title. So, when it comes to unregistered title, the question of proof of ownership is a question which relates to proof of title deeds. Because unregistered land operates very differently to the registered title system, we can't just go online to the land register, we have to do it through a different process. The purchaser of an unregistered estate essentially will investigate the title deeds of what we call the vendor, i.e. the seller of the property, to find the proof of ownership of the estate. Now, the general legal approach here is that the purchaser examines the proof of title going back to what is known as the root of title. This is the most recent conveyance, which is at least 15 years old. That is what is known as the root of title. So, if we have a particularly old piece of land that has a very long history of passing through different owners and the title being transferred, you don't necessarily have to go all the way back to the very beginning of documentation on this title. You want to find the most recent conveyance, which is at least 15 years old. That is the root of title. This is a statutory requirement, and it has been reduced from 30 years, which was under Section 44, subsection 1 of the Law of Property Act of 1925, and then it has been reduced from 30 years to 15 years in Section 23 of the Law of Property Act 1969. So it used to be a 30-year requirement, now it is a 15-year requirement. When it comes to third-party interests, and when it comes to the taking place of a conveyance, when the transfer of title takes place, for example, there will be a transfer of title from the vendor to the purchaser of the estate. That is quite easy to understand. However, when it comes to the second issue that is required, is this question of conveyancing, i.e. the identification, or at least the question in conveyancing is the identification of various rights and interests which may exist over the land in question. Now, these rights and interests may be legal, as we noted in a previous lesson, or they may also be equitable. Now, these could, for example, be things like easements, they could be profits, they could be restrictive covenants, etc., etc., etc. All of these are different ways in which we can think about interests in land. The main issue here is to investigate whether these rights and interests could bind the purchaser. If I'm going to purchase a piece of land, let's say it's an unregistered piece of land for the purpose of this chapter, I want to know if I have to now adhere to the rights and interests of all these third-party individuals who claim to have an interest over this piece of title. So if they're legal, then I'll have a legal obligation to be bound to them. But if they're equitable, then there are only certain ones which will bind me as a purchaser. So essentially, a purchaser will have to do the following things in the process of conveyancing. They will have to examine whether there are any legal rights of the land, since legal rights will have the automatic effect of binding onto a purchaser, and then they will have to find equitable rights of land. So these may be registerable as a land charge. We'll get to land charges in future lessons, at which point, if they were registered land charges, the purchaser would need to inspect the land charges register and find them. Or they could be overreachable, at which point a purchaser may need to overreach, okay, which again we'll get to in a future lesson. If they're not either of these two, then they may be subject to the doctrine of notice. Legal interests in unregistered title are very simple. They will automatically bind a purchaser upon the conveyance of an unregistered title. So legal interests are much stronger and are far easier to be solidified within the concept of binding purchasers. It's equitable interest that we have to think about because they differ slightly. Since the legal owner of a title in the transfer of property may actually trump an equitable interest. And if we see that is the case, if the purchaser of title therefore is not bound to the equitable rights, then we describe that individual as equity's darling. Now, what we're going to do in the next lesson is talk about the doctrine of notice. We'll talk about the ways in which the doctrine of notice operates, and then in future lessons time we'll talk about land charges specifically to talk about how these interests actually bind onto a purchaser and the ways in which the title has to be investigated in this regard.